Has left the conference.
Well, we're boring already.
Exactly.
They're bailing on us. You wanna start?
I certainly can. Okay, so, well, I guess the place.
Has joined the conference.
No comment now. Will you let us speak later?
Maybe.
Maybe, okay.
It depends what's in it for me.
Has left the conference.
Feel free to comment anytime you'd like.
Oh, wave speaking for John.
There you go. Okay, so I think what we're going to start is everyone should have, I think the members received a copy of this via email from Donna yesterday. And by this,
Copies here in the room.
right, and by this, it is the proposed structure and criteria for state bar review of work plan, et cetera. And then there are copies that are available for the public here. So everyone that is here, if you want a copy of this from Louisa is the person you get it from, correct? Okay, so does everybody have one that they, okay. So I think that, I'm not sure exactly, Joanna, where you want to go with this. So it's here, do you want to flesh it out some more? Do you want to, I don't know, sort of, I have some questions about it. I guess I would also toss that open to other folks that may have some questions as well.
Yeah, I'm happy. Tom, do I need the mic?
Yes.
I'm happy to walk through it and sort of give you a little background on where this came from. So in response to the discussion that we were having at the last meeting, I wanted to put something on paper that we could respond to and edit as appropriate or not. That sort of lays out what sort of a direction that the bar may be able to go in terms of a middle ground. Again, I would caution that we obviously have not had a vote of the full Board of Trustees. One of the things, though, that we have had the ability to get the Board of Trustees to weigh in on.
Has joined the conference.
At the Programs Committee meeting on November 15th, Joanna was giving an update as part of the chair's report. The chair had deferred to Joanna to give an update on the stakeholder working group. And she talked about one of the sticky issues that we had sort of come across the day before, which was sort of that question, the key question of would the bar, if the bar felt that there was something that the commission wished to pursue that was adverse to the interests of the bar, would the bar need to be able to say no, that conflicts and so it can't be pursued? And in presenting that question, there was unanimity of opinion. There were probably 9 members of the board that were on the programs committee at that time. And they unanimously agreed that would be something where the bar would need to be able to say, no, there's a conflict, and so we would not be comfortable with the commission, and the commission could not sort of pursue that project or initiative or legislative advocacy. And so that concept is built into this document as well. And so really sort of what it lays out is sort of a process for projects, initiatives, legislative advocacy, amicus briefs, whatever. And it's shorthanded as projects and initiatives throughout the document. That Access Commission leadership would meet with 2 liaisons from the Board of Trustees for any of these projects, initiatives, amicus briefs, legislative priorities. Depending on what decision gets made, it could be the Access Commission liaisons, it could be the litigation liaisons for amicus brief or legislative liaisons for legislation. It's sort of any 2 of those, but it would only be 2. Meeting with them to identify the projects and initiatives that the commission is seeking board approval to pursue, and then sort of going through that. And there's criteria that's listed that the board would use to determine whether or not there was a conflict. The notion being that deference would be provided to the commission, but that if there was a conflict with the bar's interest, or if there's something that was proposed was adverse to the bar's interest, then the liaisons and the commission leadership would try and come up with a mutually acceptable resolution. Hey, instead of trying to, doing it this way, that would require the bar to set up a whole new regulatory process. What about if we do X, right? So trying to come to a happy medium there, in which case everything could proceed. And then also just laying out, as we talked about, that any project or initiative that the commission would be proceeding with that is outside of the board's identified initiatives or priorities would be done with outside resources and staff support. So that's what this seeks to lay out. It's possible that it's too subtle in places or too direct in other places. So this is something that we can use to respond to or not. I just put it out there for your consideration as sort of a way to move toward a middle ground.
Okay, so I have a couple of questions. So this does not address governance at all. And I'm concerned that we have a couple of, I guess part of it is a lack of clarity on my part. It's my understanding that Catherine's and my term expired at the end of December. There have been reappointments that have come up with the State Bar that have not been filled. The issues that the Board of Trustees, and I don't frankly know where this came down on size, and there's also some issues that all State Bar volunteers have to go through training, and that the bar has certain criteria, I think. I mean, I can look at there were 8 points or something that, and I don't know whether the Board of Trustees has adopted those, whether those would apply to the commission. There's also a discussion about whether the sub-entities sunset every 5 years. I mean, there's those kinds of governance things, which I think are important, obviously, for the bar to keep in mind. It's not clear to me whether the commission gets filtered through all of those things or not. So that's kind of one large area of governance, which I think we haven't really talked much about, which I think is something that needs to be taken into consideration. The other concerns that I had, though, were understanding that that ambiguity may or may not be a good thing. I'm not sure what the bar's fiscal interests are, because if we ask for additional staff to do X, that's adverse to the bar's fiscal interests. So I don't know exactly what's intended by bar's fiscal interests. I'm assuming there's like a de minimis, we'd really like an extra tuna sandwich is probably not what's intended.
Fair.
That conflict with the bar's statutory obligations. I don't really know how the commission ever does that, and I really don't know what that means. And interfering with the bar's relationship with the Supreme Court. Again, I don't know what that means, and I don't know what's intended by that. And so, given the fact, so I guess I'm just sort of, I'm a little bit flummoxed, maybe a good word, by some of those because they're awfully broad and ill-defined. And so I don't know what any of that, well, I'll stop repeating myself. I don't know what those mean.
Donna, did you want to address any of those?
Sure. Starting with the first point, you're absolutely right. This does not address governance. That those would certainly be questions that we would need to get to, ideally by at the end of the meeting today. The last item in the agenda was intended for us to develop the recommendations to the board, so that would have to be in there. Judge Uhas was referring to the global recommendations that were adopted by the Board of Trustees as part of our governance review of sub-entities. which included, among other things, that the default size for sub-entities would be 7, with the ability to sort of demonstrate the need for more than 7. That there would be the orientation was just ensuring that the bar was delivering the same orientation to same sort of technical parts of the orientation to everybody. So you heard the sort of same message that the committee bar examiners heard, that the Legal Services Trust Fund Commission heard on things that overlap. Obviously, there would be issue-specific orientation, but you're all submitting travel claims and things like that. So that's what that sort of orientation tenet was about. One of the other global recommendations was the elimination of nominations committees from the sub-entities, and that the appointments liaisons from the board's executive committee would be making the ultimate recommendations for appointments to committees. Obviously, that would need to be done with some input from the leadership from the sub-entities, because you may have a lot greater knowledge of some of the applicants, but there wouldn't be a nominations committee process. Those were
For bar appointments.
For bar appointments, yes. Those I think are the big ones.
So the bar would appoint members of the commission.
That are
I mean,
appointed.
because what's happening now is there's a nominating committee on the commission. We have applications that come, I think this is right. We have applications that come to us. We have a nomination committee that vets the nominees, may make contact with the nominees, do an interview process with them, and then the nominating committee, who I believe is chaired by Janice Hirohama from the League of Women Voters, then makes a recommendation to the commission that we then recommend to the Board of Trustees that Joe Smith get appointed. That then goes to the Board of Trustees. The Board of Trustees has, not in a rubber stamp inappropriate way, but there's never been an appointment that the Board of Trustees has ever said no to that I'm aware of.
Right.
So that under this plan, the application would go through the Board of Trustees. So we would have no input into who is on the commission, with the exception of, I guess, if the Board of Trustees said, Joe Smith has applied, presumably we could say, well, we're really not that interested, at which point the Board of Trustees could say, well, too bad, Joe Smith is on the commission, or, okay, great, we'll not then appoint Joe Smith.
Yeah, I mean, I think what the global recommendations envisioned is that those things like the poring over the resumes, doing the interview process would be happening by the appointment liaisons to the board executive committee, as opposed to by the committees themselves.
With input from leadership of the committee, so whoever leadership decided to
Right.
do. So if you had somebody familiar with the process, that you wanted to work with the appointment liaison about going at looking at the applications and providing input, there'd still be that. It's just eliminating the multiple committee steps to get to the nominations.
Yeah.
So Mike, I guess, so if there's only 7, if there's only 7 and they're appointed by the Board of Trustees, what happens to, the value of the commission has been having appointees from a variety of different entities. So the Chamber of Commerce, the Senate, the Assembly, there's a whole list, League of Women Voters, a whole list of people. And so I guess so if we applied the same rules, am I to understand that all of those other appointing entities would no longer have appointments to the commission?
If we were to
Has
apply
left
the
the
same
conference.
rules, I would think what would happen is the number of state bar appointments would reduce significantly, and that some of the other appointing authorities would continue to have appointments. So I don't see the bar appointing all of the members. I see the Judicial Council and Chamber and LAC, sort of, some combination of the existing appointing authorities. And it may be that this commission would argue that at the very least we need to have one representative from each of the existing appointing authorities, and so therefore the minimum size that the committee can be is 15 or 16. That may be something that this group would suggest to the Board of Trustees.
And then ultimately, the Board of Trustees decides that this appointing entity is in or out. So all of these decisions are made by the Board of Trustees. Right? I mean, if we came and said, we have, and I'm not sure this number's right, and I apologize, that we have 8 non-bar appointing entities, that we want all of them to stay. So already we're over the 7 number.
Yeah.
And so the board says, well, we want, one, CLA should have one, change lawyers should have one, I mean, whatever. So we're gonna be pushing 15 or whatever it is. But the Board of Trustees is the ultimate arbiter of who the appointing entities are, and all of that. So the Board of Trustees could say, Council Churches, you're out. I'm just picking on somebody, and I apologize for X appointing entity, you're out, right?
Yeah, in theory, yes, right? The existing appointing authorities were the existing makeup of the commission was determined by the board, and so the board, in theory, yes, could make a change to the makeup of the commission, of the appointing authorities to the commission.
However, I mean, the idea is, 7 is the number was used because it's determined that that's the best number for a board, a committee. However, we've built flexibility in it, and as long as there's a basis for adding to it, I don't see the board saying no. I mean, if you found that each one of those appointing authorities has been provided productive appointments that you think are valuable, I mean, that's important to the board to know that you want to leave those in place, and why. That's all. We want to know, do you think they're all important? Why do you think they're important? I don't see us just whacking people off just because we want to make it 7. I don't see that's happening.
Shouldn't the membership be outlined somewhere? Because I think this is a great start, this document. And I think maybe a little bit of tweaking and editing and to give everyone a better comfort level. But things like the size of the committee from the previous discussions seemed like they were very important to the commission, because there are various members that I think are extremely beneficial to have on the commission. So is there a way to incorporate committee membership into this document?
Yeah.
Because it's one thing to agree on, let's say hypothetically during the next few hours, we agree on some version of this document. That the size of the committee is to me really significant. If I was on the committee, who's representing, who are the representatives on the committee?
Yeah, and this was not intended to be a draft recommendation to the board of sort of all of the issues before the working group. This was sort of intended to respond to what was a particularly sticky discussion last week or 2 weeks ago, that we wanted to sort of be able to sort of nail some of this down, because this could be, not to say that everything else couldn't either, but sort of a make or break decision for sort of whether the commission feels that this is a level of oversight that makes sense and is workable for the commission, or if it's a level of oversight that is not workable. And so it was just sort of addressing that that one particular issue. But yeah, everything else would certainly need to be laid out in the recommendation that goes to the board.
Maybe before the end of the meeting, like in an hour and a half or so, we can get just a list of the appointments that make up the commission.
That would be
So we have a piece of paper to work off, everybody's working off the same thing, and we can have that discussion.
Yeah, Elizabeth will have that brought down.
Michael,
Thank you. Following on that thought, the appointees on the commission have been dynamic. It's been dynamic because it's changed based upon what the issues are that have cropped up at the time, and so we've invited new participants. I don't know if we've asked the board to bless it or not, but we've invited new participants as issues have cropped up from relevant sectors of the community. I feel it necessary, and this may be an uncomfortable observation, to point out, though, that the bar's mission is protection of the public. And undermining an independent access commission is contrary to the protection of the public. Removing the bar as a target of scrutiny of an independent access commission is contrary to protection of the public. For instance, the Jameson case, which we filed an amicus brief in, one could argue that's contrary to the fiscal interests of the judiciary. It's arguing that we should provide court reporters, that the judiciary should provide court reporters for indigent people in a time of lean budgets, and that's contrary to its fiscal interests. What if the Access Commission were told you're not allowed to say that because it's contrary to the fiscal interests of the judiciary? The beauty of the Access Commission has been that we've had the liberty over the last 25 years of being able to say things to our appointing authorities and to the public that our appointing authorities are doing things either knowingly or unknowingly that harm the interests of equal access to justice. And I think that the bar's approach on this paper, both in terms of controlling the agenda and controlling the appointments, and I'll just follow on what Judge Uhoff said about appointees of the state bar. I'm one of them whose term was expired, and through an interesting surprise, I received a copy of a general counsel opinion letter, which, based on my own legal expertise, doesn't really have any basis in law, that says that there's no holdovers. So I'm no longer a voting member, and there's no new appointee to follow up beyond me, yet I happen to be a particularly vocal supporter of an independent access commission. I don't find that to be consistent with the bar's mission of protection of the public.
Well, that's a good argument for separating from the bar, because the board has to have oversight and has made it clear they plan on having oversight. I don't know that it will ever become an issue. It depends on whether or not the commission takes positions that are adverse to the bar's interest. And just because it's a public protection mission doesn't mean that the commission wouldn't need to be taking positions that are contrary to the bar's interest. And we talked about a couple examples at the last meeting. If the commission was strongly pushing and going to the legislature for a triple LT program to be regulated by the bar, and the bar didn't have the resources, the bar would want to say, not right now. It may not be in the best interest to do that, but the board has fiduciary responsibility to the organization. And as long as the commission is under that umbrella, we are required by statute to make sure there's oversight. It hasn't been done right over the 25 years. That doesn't mean we can't be doing it right now, and the board has decided it wants to do it right. So I think you make a very good argument for an independent commission.
I'm sorry to interrupt you.
Go ahead.
The interpreter issue that plagued the state last year, that wasn't timely either, right? I mean, we've got financial constraints, but we've got people's due process rights at issue. We've got people's respect for the rule of law at issue. And that's what we're risking by trying to roll the Access Commission under the purview of one of the appointing authorities. The legislature allows the Access Commission to operate independently. The judiciary allows the Access Commission to operate independently. They're appointing authorities.
Yeah, but
The
they're not
governor-
under the bar.
the governor-
They're part of the bar, though.
Only perfunctorily. We've
Well, General
operated
Counsel-
independently for 25 years, Joanne.
You've been allowed to operate with operational autonomy, that phrase that General Counsel's office uses. You're still been created by the rules of the board. The board created it. The board, it's under the state bar. It uses state bar resources, state bar staff. And we are taking control of the organization in a way we never have before on the board and should have been doing, but weren't. And the California Lawyers Association would also say public protection is their mission. But the lawyers don't necessarily have the same interests as the bar. The bar regulates them. So we can all have a public protection mission, but it doesn't mean we have to all be on the same page. And as long as the commission is under the state bar, there's a limit to how far the independence would be allowed to be. Again, if it's adverse to the bar, whatever that is, the board is going to want to say no. Catherine?
It seems to me that one of the things that's missing in why we get into these discussions is because, as you say, the commission was created by the bar, and the bar at various times has issued different opinions about what does that mean. Sometimes they say it's fine to be independent, and here's what that means. Other times they say, no, there's more control. So I actually think that the commission needs to have statutory authority that says, here that we are creating an access commission. Here's how this commission is going to operate. Here's the authority that it has, so that we're not in a position where, that it sort of depends on how the bar is interpreting the authority of the commission. And that alone will provide, I think, a great deal of clarity about how it should operate. That might in fact then lead to the conclusion that the commission has to be a separate entity, and that we then have to work through what does that mean. It's really what I said at the last meeting, which is, although I was the creator of the concentric circle hybrid model, I've really been persuaded through this that the complexity of sorting that out and figuring out when something is or isn't in the bar's interest is just going to result in ongoing disagreements about whether it is or isn't in the bar's interest. And I appreciate what you said is the bar in the end gets to decide. And so I really, as a piece of this, want to put on the table, like, not just assume that the recommendation is a hybrid model, but to say, what does an independent model look like, and be able to present that as, at least as well, if not the only recommendation, because I think it is the cleanest path forward. And just the other thing I'll say about that is, I don't think that means that we don't work together on access issues. So there will still be the middle area where we're working on something. The bar can say, we'd like to partner with you on a project that's a bar project, and the Access Commission can say, that's great, and we all understand that particular project is a bar project that the bar is going to take more of a lead and control of. And then there will be other things, because it's an independent entity, that the bar does, that the Access Commission does on its own. And that, I think that I honestly believe that is the better model. It allows for collaboration when it makes sense, but it allows for us to just create statutory authority for a commission, much like we did for the California Lawyers Association, and have a path by which we transition to that new model. So I've listened to all of these discussions. I respect every person in the room, but I really feel like we've got to get this other option on the table so we can fairly say which of the two actually makes more sense, which of the two is going to ensure that both entities can carry out their responsibilities and their missions, because it is complicated to figure out how this works together.
Right.
And if I may just add one more, it might not work together. Because there are times where it's foreseeable that the lawyers of the state, as they're regulated, or the regulating entity of the lawyers of the state, might be doing something contrary to access to justice. And then it behooves an access commission to call them out on it. And the bar should welcome that, because the bar's mission is protection of the public.
I agree with both of your positions, that an access commission that is truly independent gives it the authority it really needs to be the most effective. I don't think that model works under the state bar, and I agree separation makes sense so that you can have that independence and pursue everything. How we get there is, something that have to be figured out, but I'm not sure everyone in the room yet agrees with that. So I would be curious what other people think.
Well, let me respond, because I've...
Is your mic on?
Yes, thank you. So I have been advocating for trying to figure out a hybrid model and staying with the bar pretty strongly, because I do think there are benefits to that. But I see this proposal as problematic in fundamental ways that do also lead me to the conclusion that separation from the bar probably makes sense. And I do want to explain briefly, because I think it's worth focusing on why. And I understand what you're saying is that the bar feels like it now needs to have oversight and control. And I go back to our last working group meeting where we separated out oversight versus control, because oversight, I think, does make sense and is workable, where there's communication, there's reporting, there's working plans, there's discussion. There's making sure we're fulfilling our mission. You know, we can adjust it, and there might be some particular areas where there are sensitive areas like legislation or lobbying where we need to have some kind of, you know, heart-to-heart or real discussion, work it out. Improving collaboration, better communication. But what this is this is complete control. This is the commission cannot take any initiatives, actions, positions, can't issue reports, can't take a position on legislation, can't file an amicus brief unless it gets permission and approval from the bar in one form. There might be streamlined ways to do that, which is helpful, but it still means that the Access Commission will not be able, has to get approval for any position it takes and will be limited, or either through a chilling effect or through actually saying no if there's something that might be adverse to some interest of the bar. And while it hasn't happened in the past, this is the frustrating part. I think we are on the same page that we're all want to promote access. There really is, it has historically worked, an independent Access Commission or autonomous that is able to take positions and weigh in on important access issues. And I think we could potentially have a hybrid model where there's oversight, but I think what is being provided here is just a really complete control, making the commission a sub-entity of the bar that is not able with disclaimers or explanation. The whole point is, I think, for a hybrid model to really work, in my opinion, the commission has to be able to speak not on behalf of the bar, but to say we are speaking on behalf of the commission on access issues, and that's our mission and goal. So we don't speak on behalf of the bar, and that can be clarified in many ways: board resolution, statute, from the court, disclaimers. But if it's not being accepted that the commission can't speak with, even with disclaimers, then we can't speak unless the bar agrees with us, and that's a problem.
At the programs committee meeting, Deborah Manning again indicated that, in her opinion, that the legislature can't distinguish between the bar and a committee, even with disclaimers. So I think that I've become very comfortable with the idea that the Board of Trustees is uncomfortable with disclaimers because they don't feel that provides sufficient insulation for the bar. And so I think that disclaimers are probably, while I disagree, I think that the legislature can figure this out, that the court can figure this out. I think that the Board of Trustees, I watched the tape, based on the conversation that was at the Board of Trustees meeting, that a disclaimer is not an option that's available to us.
Can I tag on to that a little bit? And I think, I don't want to speak on behalf of Debbie, but I expressed a similar concern at our last meeting. And I think that the root of my concern is not so much that the legislature is going to be confused. I think it would be clear to the legislature that there are mixed messages coming from two bar-affiliated entities, right? The bar itself and this sub-entity or a pseudo-sub-entity, whatever it is. And I think that is where the potential harm lies, that there are discordant messages or mixed messages, and why can't these people get on the same page? So I just want to make that clear from my perspective.
Well, nevertheless, disclaimers aren't going to work.
I think you're right.
Yeah.
So at the last meeting, Allison had asked the commission to come back with, what does the commission want? So is it that the commission wants to be independent and separate from the bar? Is that what I'm hearing?
I think at the end of the day, honestly, that in light of, let me before I'm gonna be a lawyer, a sort of a recovering lawyer, if you will, and not answer the question straight up.
This would not be allowed in your courtroom, I'm guessing.
Which is not. However, I have some leeway here. I think that the bar's desire to get its house in order is admirable. I think that I've had an opportunity to deal with senior level staff and mid-level staff and at the bar, and they are to a person remarkable. I think historically, the commission has been treated very well by the bar. I think traditionally and historically together, we've done really, really good things. I think the commission has held its own. I think the commission has made the bar look good. I'm a little mystified as part of this because while I understand the bar's desire to get its house in order, I also believe that if it ain't broke, don't fix it. And so I'm a little mystified as to how we got here, but we got here. Having said that, I think that the sense of the commission is that in order for the commission to do the work that the bar, Toby was on the initial committee, that the bar envisioned for the commission to do, which was protect the public from an access perspective and be a little bit of a burr under the saddle of everyone, and to take positions like the one that we just talked about on the Jameson case. We need court reporters in courtrooms. We do. They're expensive. We need them there. It's an access issue. I'm not going to say I know personally, but I sort of know through rumblings that that particular Supreme Court decision, which I think is an excellent one, has caused some gas bubbles among some of the counties because of the economics. I'm proud of the position that the commission took, frankly. I think that the commission took a position when the legislature did not pass a bar dues bill. It was dues then, not fees. And we took a position that, Supreme Court, you really ought to, give them some money because they need some money, but you ought to think about access as part of that, which is not adverse to the Board of Trustees in any way. I think that unfortunately, there has developed misinformation and a misunderstanding in the Board of Trustees about the commission. And again, at the last Programs Committee, the comment was made that the commission is out proposing legislation and looking for a legislator to carry the legislation. That's not true. That's never been true. But that wasn't fixed. Nobody stood up and said, hey, wait a minute, that's not right. That's not what's going on out there. And so I think there's been a certain amount of misinformation at the Board of Trustees level. Not that I think that communication couldn't fix it. But at the end of the day, I think that Californians are best served if the following occurs. That for the next year or so, that we work hard with the bar, who, as I said, I have never met a more dedicated, remarkable group of people. Work hard with them to separate from the bar, go off on our own as an independent entity, work with the legislature to make that happen legislatively, and work on figuring out how we fund it. And I think into the future that we become friends with the bar from the standpoint that we work together. They come to our meetings, we go to their meetings, they talk about, hey, what do you think about this about access? And we come back and say, hey, we're thinking about this, what do you think about that? The issue of the triple LTs, for example, talking about limited licensed legal technicians. Maybe we come to the bar and say, hey, we're really taking a look at this. What do you think? And through a discussion, the bar says, we can't manage fiscally, we can't manage controlling them, not controlling is the right word.
Regulating them.
Thank you. We can't manage regulating them. And so we go, maybe we ought to go to the Supreme Court and let them come up with some rules like they did in Washington, and maybe between the three of us we can figure out something that's going to work well for access to justice, that gives the Board of Trustees a comfort level in the input, gives the commission a comfort level in the input, and gives the Supreme Court a comfort level, and we all have a comfort level that we're all pulling together, as opposed to we're going to the Board of Trustees saying, hey, we really think triple LTs are a good idea, And the Board of Trustees not taking a swipe at the board by any stretch of the imagination.
Go for it, do it.
No. Essentially says, no, we can't do that. And then what may be a really good idea or a really bad idea, but a really good idea gets shut down for really good reasons, as opposed to a really good idea getting really fleshed out and then shut down for really good reasons, or we affect the state of California in a very positive way. So I think that that the discussion here should be that it's been really a very positive experience for the last 25 years. It's been wonderful for everybody, but maybe in light of the new bar and in light of sort of the new world order, that it's best for us to think about moving on, seeking funding, looking for legislation, and figuring out kind of what do we do next? How do we work with the bar, as opposed to how do we be a sub-entity of the bar? That's my sense of what the commission wants.
Jody and Michael?
So
I'm sorry.
I speak as the outsider looking in, because I'm not, with the bar nor with the commission. But and I mentioned this last time, my sense is that because there haven't been issues, as Amos has said, there haven't been issues, but there appears to be a huge lack of trust between the two entities. Not having had any issues for 25 years, thinking there will be issues. I do believe every entity needs some level of oversight. No government organization operates independently. If there's anything like that, that does not exist out there. If anybody's thinking that exists, I think that's wrong. I guess I'm really disappointed because I feel like we spent, 3 meetings and folks have wanted to separate right from the get-go. I don't sense a good faith effort to try to make this work. I just don't. I think that's my sense. From the first meeting on, we've talked about separating. And I'm not saying everybody, but I just sense that that's been what folks have wanted from day one, is let's just separate. We'll do our thing, you guys do your thing. And I think this is a good start. I don't think it's perfect. I think that last bullet can be worked on to give the commission more independence or whatever it is you want. But there is, when an entity like the bar, that's an umbrella entity, does have to have oversight. That doesn't mean they're going to control you, but I think the underlying issue here is a huge lack of trust. And because of that lack of trust, you would have 2 entities separate. Commission becomes independent. It's another, I think, hit on the taxpayers of California, maybe, depending on how they end up being funded, because you're going to duplicate. You're going to duplicate some admin functions here. How is it more cost effective for the commission to separate? How is that more cost effective? Or does it matter that it's cost effective or not?
I think that's one of the things we're talking about we have to work on over the next year. I see the commission more as a disruptive body. That's the point of their existence, essentially, is to disrupt thinking to increase access to justice. And I think that's a vital role for them to play. And the challenge comes when they're trying to be directly disruptive on something that adversely impacts the bar itself. I don't think
that hasn't happened yet.
I know it hasn't.
We keep talking about that's never happened. We're separating based on a hypothetical because there is lack of trust between 2 entities. Is that a legitimate business reason for separating?
Well, as far as I'm concerned, that's the commission's call.
That's what we're talking about.
It's the commission's call. All we're doing is asserting, if that should happen, what would have to happen on the board's, state bar's side. Doesn't sound like they're comfortable with that. So ultimately, it comes down to their decision whether or not they want to stay part of the bar. And
so I share some of the frustration. I certainly hear the frustration and respect the frustration. And I also come with the perspective, again, personally, that there were several people, many people probably who had separation as the goal, or you know, we're thinking about separation. But from my perspective, where the commission started having discussions of what's going to happen with the commission when the bar and the sections were separating, where is access going to fall? And it's been now a couple years where there's been uncertainty of what's happening, and especially over the last 6 months to 12 months, it's very clear when staff recommendations was the Access Commission can't do anything, but the proposal was going to be the Access Commission can't do any of its initiatives other than the bar initiatives at all. So we've been looking at our wings being clipped. One way or another, we're going to be limited. And the status quo, from my perspective, is independence in funding. That's how
Has joined the conference.
has worked and worked well without really problems with the bar for 25 years. And it seems like with the new bar and with the need to exercise control and not just oversight, I do think there's an important difference, because I don't think there's a problem with working together and communicating better and seeing if we can work out issues. I don't think anybody's having a problem with that. I think the issue is if there's an issue, whether it's an amicus brief or a legislation or a new regulation, and there's an access issue, is the commission going to be able to voice an opinion that the bar might not be behind or might disagree with the bar? And that, again, even though it's theoretical, it is sort of fundamental to what the commission is.
So why not wait and see if that actually does occur? And at that point in time, why not do a pilot and try to make it work under the new world?
So from my perspective, and I'll just say what I was trying to express before, is this proposal is complete control. So I think this, for the hybrid model that I was envisioning and I was discussing before, was we would do work plans, they would be reviewed, there would be input, they could be changed, but that the commission wouldn't have to get approval and permission for every report and every position and every stance it takes, and, you know, subject to bar review. And it seems pretty clear that the board in the last programs meeting and representation is not comfortable, even if there's a disclaimer and it goes under this, has to speak with one voice. And I think that's the inconsistency. If there was a hybrid model that allowed the deference to continue operating with autonomy, that would work, but that is not being accepted.
So I think, I don't want to put you on the spot, but Judge Dillon, Toby, do either one of you want to make any comments at this point?
Yeah, I would just say that the example I gave last time was our administrative agency work. And that's at the heart of what we do, which has zero controversy. And again, the whole notion that we've been or have done anything in conflict with the bar has not happened. So then that's the concern, which did not come from us. And we were told flatly not to work on our administrative work, which had nothing, would not be a conflict. So that's part of how we come to this place, is we're being told that we cannot work on something that is extremely important to the commission. And that's a concern, because that's our work of the commission. And again, as I said last time, that's probably how most Californians have access issues with administrative agencies. It's not in court. And how we would do that work is unclear. And where would we obtain funding? That's not a priority of the bar. So we're going to be doing that work under this proposal, I guess, separately. And then we'd have to go, and where would we obtain funding to do that? Would we go to the legislature? Would we fundraise? And that's a concern, and that's a perspective of Does that mean that we should be independent? So we can do that work? So at least some part of us is going to have to be independent to do that work, because that's something that we believe.
Would you not be faced with that if, let's say, you have 2 or 3 staff and that administrative work is really important, but then there are a couple of other projects? You may not have bandwidth with the few staff you have. I mean,
We'll have to,
every entity is faced with that
has to make
regardless,
priorities.
right?
Right.
And I think where that becomes an issue then,
One more time.
where that can become an issue is if what the board decides are the access priorities and what the commission decides are the access priorities don't match. And if the board says, you can use our funds to fund these activities, and we say, well, you know, those are fine activities, but they're not the things we think are most important. We think these things over here are more important. So now, it's not us setting the priorities. If that now has to be outside of the bar, even if the funding available for access issues, you know, is there, it's just not what we think are the most important things. Let me respond to the request about, you know, where is this? My sense of where the commission was, and I know where I was coming into this, I've been involved with bar activities as a volunteer in various bar committees since the mid-1970s, and have been on some bar commission or committee or whatever probably ever since. On COPRAC, on the Jenny Commission, on you name it, I've been there. So I have great respect for the bar and the work that I've done with the bar. And my preference was to find some way to stay within the bar. And the messages that I've gotten from bar senior staff, from board liaisons to this committee and to the commission, and you know, observing the programs committee meeting and the like, leads me to the conclusion there probably isn't another option of staying within the bar. It's not something that I want, it's not something I think the commission wanted coming into the process. But I think that's where I am on it.
I would only add to that as a member of the commission for the last 6 years, the last year we have really been stifled in the work that we've been doing because of this interplay with the Board of Trustees and with bar staff. And it's not something that any of us wanted. The status quo was great. It was working just fine. We had a collaborative relationship. And it's not there now. And none of us who are on the Access Commission signed up to be on the Access Commission to do the back and forth with bar staff or bar leaders about whether we can do the work.
Ellen Miller Sharp has joined the
We're spending
conference.
a lot of resources, even in these working groups, that we believe ought to be dedicated towards pursuing the goal of access to justice. And it's interesting, when I became president of the Sacramento County Bar Association, the day before I was sworn in, I came down to San Francisco. I think it was, I don't know, this room or something like that, but there was a Board of Trustees meeting. It was a Governance in the Public Interest Task Force meeting at the outset of all of these discussions that have led to the changes in the bar. And I got up and I made a pitch for a unified independent bar, and I was met with some pushback by some of the members of the Board of Trustees, Board of Governors at the time. And they asked me, does your representative on the Board of Governors represent you? And I unwittingly said, yes, of course she does. And they said, well, she should be representing the public. And I said, well, she does. Because to represent me as a lawyer is to represent the interests of access to justice and equality under the law. And that's what I believe, I know my governor at the time did. She was my elected representative. But that's why we're all here, is to pursue those interests that make our profession what it is. It's a pillar of sustaining democracy. It's not about control by one entity or another entity. And while I'm sympathetic, as others have said, to the bar's desire to get a handle on its volunteers, to try to rein us in is contrary to everything that the commission was set up to do, and is contrary to the work that we all signed up to perform.
Yes.
This is Selena Copeland, the Executive Director of Legal Aid Association of California, an appointing entity for the benefit of folks on the phone. I just want to echo Toby's concerns because what really spoke to me in this document is that it raised more questions than it answered. But what really jumped out is the fact that it shows that there's a potential narrowing of what the Access Commission can do with state bar resources. Because from my reading, it looks like the Access Commission can only use bar resources for board-identified initiatives or priorities. That's separate from this kind of like negotiation of other stuff the Access Commission can do, which I think is the biggest piece, and then the smaller piece of what could be conceived as adverse. And I worry about things that could be conceived as adverse, like Jameson, or any issues, anything that we argue for that costs money could be seen as adverse either to the judiciary or to the bar. But this big piece here of everything else we do, whether it's the administrative agency work or work we do to increase access to justice in certain communities, that may not be a board identified priority. And so the Access Commission will have to raise money for all of this, for everything that is not part of the narrow board identified priorities. And so why doesn't the Access Commission just move away? Because if there's just a piece here that the bar was willing to pay for anyway, I think that it's inefficient to stay in an organization that is only saying that they'll help us on what they think is most important. And from past conversations of the Access Commission, when we asked Ms. Wilson for some examples, she said, oh, well, the only thing that overlaps that the bar is currently identified is the rural attorney desert piece, I believe, or rural LRAT piece. From past Board of Trustees meetings, the strategic planning. So she gave one example that would have been the single board identified initiative or priorities, which everything else we do is separate from that one. So I just worry, I don't think it's efficient to stay an organization that won't provide the staffing that we need. And by controlling the purse strings of the staffing will really impact the ability to do any work.
So I have a question for you, then I have a comment. The rural stuff that you are doing, is state bar staff involved in that in any way?
They notice the meetings, so they follow Bagley-Keene requirements to notice the full meetings of the rural task force, which is posting agendas.
Right, but gathering data, writing reports, are they involved in any of those things?
They participate in phone calls, but I believe they haven't gathered any data, although Elizabeth can correct me. In fact, LAC staff is drafting reports along with Professor Lisa Pruitt.
Right.
So we've spent, several dozen hours of writing, but state bar staff just joins phone calls.
Fair enough. And the administrative agency report in the past required some state bar staff. I'm not sure how much, frankly. Currently, it's been all volunteer. There's been no state bar staff involvement at all, is that right?
So Elizabeth, in the last little bit, confirmed with someone that they didn't have other edits, but otherwise the state bar staff has not been editing it.
We did review it.
Fair enough. Fair enough.
Good job.
So.
Did you have edits?
Yay. So my concern, and that I just sort of want to toss out there, is that with no state bar staff involvement, we're going to have a report. With little state bar staff involvement, the administrative agency report, whatever we're calling it these days, is out there. That and again, no disrespect to Leah in any stretch for any stretch of measures, has already made it clear that she's just not at all interested in it. So we're now in a place where there's been a ton of work that's gone into this thing. That again, as Tim indicated, or Judge Dillon rather indicated, is really without controversy, is just not going anywhere. I presumably, if the state bar says we're not interested in anything but the one attorney desert piece, then either LAC publishes all those things or they sit in a can, not going anywhere, without any involvement from the state bar. And again, non-controversial in any way that I can see. Maybe it is, I don't know, but non-controversial. So we're kind of in a place where, while I agree with much of your outsider's view, I'm also concerned that we're not going to move the ball forward. And so if the bar doesn't want to be involved as part of the published by, which again, I'm not taking a swipe at them, I'm not. But if they don't want to be published by because they don't think that's within their purview, they don't think that's within
their interest level, they don't think that's within whatever they don't think it's within, and it's not costing them any money, then the commission, then we might as well just have LAC do it and call it a day, right? So I'm kind of, while I agree with, is it efficient and all those other sorts of things, probably not in some respects, but probably yes in others. But yeah, I think along the line, there has been a breakdown of trust between the commission and the Board of Trustees. And again, I started off saying, I'm not sure what got us here. If it ain't broke, don't fix it sort of thing, but we're here. So.
Just two comments. One, I think it's exhaustion because it for many of us has not been just these meetings. We've been meeting with the bar for over a year, maybe a year and a half, 2 years, thank you. It's too painful to think about 2 years of my life spent working on this. And I think there were productive discussions, but no real resolution, and we end up in exactly the same, it's kind of like Groundhog Day, honestly. Like every time I come to a meeting, we end up in the same place. Like good intentions want to work together, which is really why I said at the last meeting, I have moved to a different place. Let's figure out what we can work on, but let's do the other work independently. And I want to just comment a little bit about the administrative cost. I actually don't agree that it's going to be more money spent on administrative cost. In the nonprofit world, which is the only world I honestly know, my agency's admin overhead rate is somewhere between 11 and 12%. I don't know what the bar's rate is, but I will bet my last 2 cents that it is higher than 11 or 12%. And so on the work that we're doing independently, I much prefer to pay an 11% administrative rate than a 33% or whatever it is at the bar, because that's going to cost the Access Commission fewer dollars, and we can spend those dollars for actually copying the report or something like that, as opposed to kind of the administrative cost related to it. So I think there's ways that it actually can increase the efficiency and the costs that are associated with it. And, I'll just go back to, I think, creating the Access Commission in statute, working through what those details look like, look at the governance structure as a piece of that, look at what is the authority that the Access Commission has, and then work hard on how is that get funded is, really what we should, that should be the overarching recommendation, and, fleshed out a little bit about what that would be, and then working hard to get the legislation introduced and kind of make that transition, much like the California Lawyers Association did.
Yeah, I would just add that for myself, and I know the other members of the commission, we came here trying to make a deal to stay together. I'm concerned because we have been not shut down, but we've been for a year or more, and then going forward is another year or more where the work is really, what are we going to be and are we going to survive? And so that has been a concern. We came here because my concern is the stability of the commission, and I don't see this document as a middle ground at all in terms of for stability of the commission. And that's been the concern, that's been voiced is we haven't been doing much for the past year, and it's been difficult, and we do use our own resources. And what's that look going forward is a concern. But I certainly came, and I know others did, trying to work with the bar to make a middle ground. But I don't think from everything I've heard, I don't think that looks like it's possible.
And I will also just add that, as has been alluded to, some of the discussions weren't in this working group. So both over a longer period of time and in between working groups, there's been, I think, some clear messaging, and I think it's consistent. So I don't think it's speaking behind anybody's back, but I think the consistent message that we're hearing is that the new bar needs to have complete control and is not comfortable with disclaimers or other messaging that would make the bar comfortable that the commission can be a disruptor or take positions that maybe the bar can't get behind. And I do think that is fundamental. So I think these resources issues are critical because we also discussed during the last working group that the model of staffing, even in the hybrid model, is going to change. So with independent staffing, I think that's going to be much more efficient as well if we have one person or two people that are staffing the commission. That's more closely aligns with how it's worked very well for the last many years, as opposed to the new staffing model, which is going to be limited on only certain projects and initiatives and dispersed among several different people. So I think there's an efficiency point as well, both staffing more of the work and staffing it within, 1, 2, 3, whatever staffing the commission's able to have. And I think we also learned from the access report that we all got and looked at before that the staffing model makes a difference. The funding and staffing, having stable, ongoing, reliable funding and having professional staff, again, like what we've had and enjoyed in the past, I think is the model that has worked well and will continue to work well. And really staying at the bar is change, as opposed to what we're talking about is maintaining more of what's worked so well.
So just 2 clarifying points. One, offline, we should talk about the administrative agency report because we have different memories of the sort of definitive nature of the bar statement on that. So I'd like to talk to you guys offline about that and see what we could do on that.
Can we include Justice Roby with that?
Sure.
I feel like, I actually think there is the impact felt in Los Angeles, where most of us were, with a what was perceived to be a very clear and very strict statute. I mean, put that
Catherine,
together. And
I'm on the
felt
phone. This is Leah, and I'm sorry to interrupt you, but I've just heard this so many times, and I think it's really important for me to clarify what I said. I was asked an example of something that might not fall within the bar's definition of access, acknowledging that the bar had not defined access. I was simply asked to give an example, and I said, for example, something that comes to mind is the admin agency report, which you had just been discussing. And I expressly indicated that that was my Leah's opinion, not the opinion of the board, that I had not discussed it with the board. It was simply an example that I provided. And so how that's become, the position of the bar, or it's become that we blocked the admin agency report, I'm really unclear about. Because it's one statement that I made when prompted to give an example of something that may not fall within the bar's definition of access. And it was simply that.
Leah, I don't want to get into a fight. I was trying to sort of give an out that said how it was perceived for those of us in Los Angeles when it was communicated from San Francisco. I never doubt what people believe they said. It's not how it was perceived. And I don't think a subsequent conversation about it is going to resolve anything. All I can say, just like you can say, I only meant it as an example. I can only talk about it as the impact that it had on me, hearing that at the meeting, that you would, so that's all. I don't really think, I've actually let it go from every meeting other than now, but every time it comes up, I cringe, and this time I chose to say something about the impact it had of those in us in Los Angeles.
And the only reason I suggested that I wanted to talk about it was not to talk about it, but was to talk about sort of how it moves forward. That was, I'm not interested in having another sort of prolonged discussion about it either. It's just a matter of where does it move from here?
Right. This may be we agree to disagree and just simply let what should be a sleeping dog lie.
I guess because the commission at its last meeting voted to approve the report and issue the report. So I think the remaining question is whether that is okay with the bar at this point. And I guess I'm interested in that because I think that part is actually relevant to this discussion, with the commission having taken specific action at the last meeting that no one objected to.
So it was approved by the commission with the understanding that it was going to be further edited and then Elizabeth was doing a review of it as well, and then it was gonna come to me.
Okay,
And that
so-
was where it ended.
Okay, it actually, the motion was that staff, that Panita, who had looked at the language access section, would be consulted to see whether she had any changes, but absent any changes from Panita, that the commission approve the report. That was the action taken. It was not mentioned that our staff was reviewing the report. It wasn't mentioned that it was going any place other than that. It was from the commission's perspective, with staff in the room, a motion made to approve and issue the report subject to any edits that Panita had.
And that's, I mean, and I think, you know, and that's fine, we can sort of discuss it after. I think what we heard from everybody here in the room was separation, it makes the most sense and is the way to go. So I'm not sure that sort of talking through precisely the next steps of when we get this out the door and whose name's on the bottom of it is productive to that conversation. The second point that I had wanted to make is just sort of my perspective, and again, this is certainly not, we are free to have sort of different opinions on this. I just wanted to put out there that I do balk a little at the statement that what the bar has said is that the bar needs complete control. The bar has put forward something that is that is not treating the Access Commission or I have put forward something that is not treating the Access Commission in the same manner as other sub-entities. I absolutely understand that that is still a level of oversight or control that is too much for the Access Commission, but it just sort of rubs me a little bit the wrong way to suggest that what the bar is trying to do is exercise complete control. And so that I just sort of needed to say that in response, Amos, to what you had said. But maybe the next step is to sort of move on to the sort of part of the agenda where we talk about what separation would look like. Or, you know, Judge Uhas, I don't know if that's something that really would make more sense if we've sort of come to a conclusion of the recommendation to the board is separation, and that we have a small sort of group of people who work out, you know, an agreement of what that looks like. I don't know how you and Joanna want to move the meeting forward.
Well, I definitely think we've canvassed the room and we have a very good opinion of where we all are sitting on this issue to the point where we can make a recommendation on that level. Jody, you can issue a different report if you like.
But don't use bar staff to write it.
That's right. I learned that the hard way myself. So we need to decide what the next subject is that we're actually going to talk about to make the meeting productive. I don't think, if that's the recommendation, I don't think it makes a lot of sense to talk about governance, for example, because what we can do is talk about, you know, go for the next year, we'll just keep everything in place, and that's the recommendation.
Well, you have no chair, no vice chair. You've got 3 or 4
When I said everything
openings.
in place,
Well, but
I was referring to you.
But I don't know, well, I don't know.
That's what we have to talk about.
Right, so I don't know what everything in place exactly means, because I think Amos was not reappointed, I think Tim Dillon was not reappointed, Mike, I think term limited off, it was not reappointed. So and I don't remember who, I mean, I'm now going back to your memory, and there was a couple of others as well. And so if we can get sort of staffed back up again so that we can do that, my suggestion would be that we've actually been going for an hour and a half. I think maybe a bathroom break is not a bad idea, but that maybe we think about a small group that would then meet to start thinking about a transition team, if you will.
Okay.
I guess my question is, do we have to have a formal vote? Do we just get a sense of what's happening? I mean, what do we do?
I think we should have a formal vote, and ideally, if we could present a recommendation to the board, sort of what that vote is, as opposed to a sense, at least, I mean, for sort of separation or staying with the bar, I think sort of the key question, which I think we've sort of done a sense of, but I think we should just take a formal vote on that.
So I'm not looking for problems. I'm really not. I think what I would honestly like to see is that we continue with business as usual that we stay at the bar, that we don't change what's worked for 25 years. I don't think that's possible, but that's what I'd like to see. That's always what I wanted to see. I don't think that's likely or possible. So I don't know who's gonna form the, so if I vote against separation, that would be probably why. But I don't know who's gonna form the motion. So.
Maybe take a bathroom break and someone could figure that out.
Why don't we take a break until 2:30 and maybe a few people can get a motion together before we return. So we'll start back up again at 2:30.
Yeah, I don't, yeah, okay.
Has left the conference.
I mean, it's good in some respects, but
So.
I think that just so we're all, I mean, I hate to sort of disagree with you, but I think that maybe putting number.
Judge.
Number 5.
Which means he just gets to order you not disagree with you.
Exactly. Right. I think number 5 would be that the commission and the board will pick a small group as a transition team. I don't know, do we need to, I don't think we need to set numbers or any of that sort of stuff, right? Just that we'll work together on a transition
Plan, yeah.
Let me, what I've got is the Access Commission and the board will establish a small group to develop a transition plan.
Why don't we say Access Commission and bar staff?
Okay, that's fine with me.
I don't know that the board needs to sort of identify who needs to be on the transition team. Because I'm guessing it won't be board members on the transition team.
You're kind of thinking.
As much as you love us.
The transmission team is talking right now, is that?
Maybe. With others, I don't know.
Welcome to the transition team. So whatever, however, it doesn't matter to me. However you want to, I mean, if you want to give the board flexibility that they could put board members on if they want, give them flexibility.
Just say the
To give it-
Access Commission and the bar.
And the bar.
That
The regular-
includes
fine.
the board of trustees,
Fine.
and then we don't have to
Fine.
spend the next 20 minutes talking about that.
That's why you're here, Catherine.
Thank you. It's so good to know I have a purpose.
Mine used to get disagreed with by judges.
No, to get overruled.
Right.
So I still have the.
Can we
right
talk about
process.
Venn diagrams somehow in this too?
I'm good with that.
So I think I would like some clarity on take all necessary and reasonable efforts to effect the transition, and also what it means authorized to continue its work.
Well, I think on the continuing the work means that which the commission has been working on over the last, existing projects and any new short-term projects that come up would continue to be done. So we would continue working on the desert, the legal desert project, we continue working on the administrative agencies project. I'm sure we've got some others that are
I
ongoing.
think at the next agenda, at the next meeting, we are developing a work plan for the next year to follow up to the last discussion we had. So I think that's how I would do the continue forward.
But the idea is, what Joanna was saying, is we continue sort of with the status quo as what was happening this last year onto the future year. We're not gonna implement other major changes that the bar is otherwise going through. We're gonna continue the status quo of what the commission has been and how it's operated. That's how I understand it.
And so just to use the terminology of the operational, what I'm hearing you saying is they operate with that operational autonomy through the transition, and that obviously we would have discussions as in the natural course of, hey, is that a direction that we want to be going in? To the extent that there's an issue, again, which hasn't come up in the past. But, so we would sort of have conversations, but there's no board process, there's no process for board saying no. Like that's
the thought, yeah.
Although the board could say no under today's rules, and we could continue to say no, the question is, how do we find out about it? We need to make sure there's good communication. If it just going forward, there's gonna have to be really good communication to get us through this. If the commission wants to take a new position on something, I think the communication has to be there. And if
Elizabeth
it's
and I can
adverse,
certainly,
if it's adverse to the bar, I don't see that happening. If it is, we'll sit down and we'll try and, work it out. But again, the board already has the authority to say no to things. I don't see it happening, but as long as everyone's just aware, it's already there.
We've survived 25 years, let's see if we can make it another one.
So I don't want to create a non-starter issue where we're going to negotiate for the next 6 months about the transition stuff, because that just isn't going to get us anywhere. So I mean, I think that I think that the commission understands that we're not going to take a position adverse to the bar. I think that there's nothing in the hopper now except for the rural access stuff, which the board of trustees, as I understand it, has expressed interest in. There's the needs study that we're involved with. I think my guess is the vast majority of the commission's time over the next year is going to be taken up with figuring out, okay, what do we do next? And so my favorite quote in the entire world is from Oscar Wilde, and it is, every saint has a past and every sinner a future. And so my view would be that we, as Jody so I think eloquently pointed out, set aside a distrust for right now and just assume that the board of trustees is going to act honorably, and that the commission is going to act honorably, and we're going to go forward and do our thing. And if we bump into a problem, then we'll sit down and figure it out. It's a delicate time for the bar. We're not interested in horsing that around in any way.
Do you want a timeline?
I think
Because this could go on forever.
No, I think we're sort of thinking in the next year, that we're certainly done by January 1st, 2019.
At the latest.
2020.
Okay, I'm sorry, January 1st,
At the
or
latest.
December 31st, at the latest, earlier if we can make it happen.
The timeline will be put together by this transition.
Correct.
Sorry, directly relating to the timeline issue is that if we decide that there's a legislative piece of this, we would want to introduce at least a spot bill or something by February 22nd.
Right, so we gotta get moving.
So the transition team needs to have at least something that they propose to Allison or to Margie and have an author at least by that date.
Right.
But all the details of that can be worked out over the next several months of committee hearings.
Correct. I'm guessing that it's gonna be all over but the shouting within the next 4 or 5 months.
Except that there won't be any shout.
There won't be.
No, we're working it all out now.
We are indeed. In fact, can we all just hold hands for a moment?
Say kumbaya.
So do you have the motion now?
So what I have, motion, recommend that the board, I left out some articles, that the board reauthorize the Access Commission membership and leadership as it was, Toby, you said in 2017.
Right, we're just trying to make sure everybody who's timed out, I don't know, we picked that date.
So as of September 2018, before.
It would have changed in
But
2017.
hold it. Part of the problem with that is that Professor, whose name is now escaping me, I apologize. Professor Pruitt was a bar appointee, was not reappointed, so LAC did appoint her. So does that mean she goes back as a bar appointee? Can we do it as of June 1st, 2018, which I think captures everybody we need to capture?
Has joined the conference.
September
2018.
2018.
Right.
Okay, so prior to September 2018.
Okay.
June is fine. The point is that the people with the most experience with the Access Commission should be authorized to be on the Access Commission to do the work, notwithstanding that their terms may have ended, or they may have termed out, or they might not have been reappointed, to just restore the membership so that experienced people.
I think there's agreement, September 2018 was the date.
September 1st.
September 1st.
Call it September 1st.
is fine.
Whatever it is.
Whatever.
Yeah, that's fine. So whose terms, the end of that was whose term shall continue through the transition. 2, the second part of the motion was that we recommend that the board continues to provide support during that I'm sure was supposed to be transition, not decision. 3, the Access Commission is authorized to take all necessary and reasonable efforts to effect the transition. 4, the Access Commission is authorized to continue its work during the transition. 5, the Access Commission and the bar will establish, what did we change that to? establish a small group as a transition team to work together on transition issues.
That sounds good. Unless there's a legal issue.
Do I have a second? Are you splitting? Okay, so you want to do the vote real quick?
Second.
Okay, all those in favor? Do we have to do a roll call or can we do it?
We have somebody on the phone, we have to do.
We have to roll call.
Okay.
Judge Mark Uhas,
Aye.
Joanna Mendoza,
Yes.
Ruben Duran,
Yes.
Judge Timothy Dillon,
Yes.
Amos Hardston,
Yes.
Toby Rothschild,
Yes?
Jody Patel, Karen Fujisaki, Allison Merrilees,
Yes.
Margie Estrada,
Okay,
Very
it
good.
passes.
Karen was a liaison anyway, so she didn't have a vote.
Okay, okay. So, what's next? What are we doing? Are we done, question mark?
It seems, I mean, we have the recommendation that the board needs. The details, this is not the place for all the details. And, you know, with the governance, I don't see any problem with that continuing. I don't see the board having a problem with that. I think that allows you to continue functioning and doing your work.
When is the next board meeting?
January, middle of January. It's before your,
16, 17, something?
26,
Oh,
25, 26.
Thank you very much, take care of that.
So we meet in December, the Access Commission meets in December.
December 6th is our meeting.
And before the meeting, after that, the board will have that.
And that's when this was required to be reported to the board?
Yes, yes.
so does anybody else want to raise an issue while we're together, or shall we adjourn the meeting? Well, I think we're adjourned, then thank you everybody for your hard work and respect and conversation. We're adjourned.
Has left the conference. Has left the conference. Has left the conference. Has left the conference.
Yeah. I mean, I think it was helpful. I think it was helpful that when Joanna presented to the programs committee, she said, here's one of the sticky issues, and that they took a vote on it. So we had the board then
Decided that I do, and you guys are going to do what you're going to do. I think to the extent that you do not want to create us as your access committee, I think we're good. I actually think we're really good. It does.